Justices of the Supreme Court of the State of Alaska.
Thank you. You may be seated.
The Supreme Court is now in session.
We're here this morning for oral arguments in the case of Kathryn Dodge versus the Lieutenant Governor and the Director of the Division of Elections, and also with interveners Bart LeBon and the Alaska Republican Party. Council are all present. Council, there's just one preliminary matter. I think you'll be familiar with this issue. We're going to follow the same conventions that you used before the master to protect confidentiality to the extent possible. So the names of the voters whose residency is challenged is already a matter of record, but there's no need to mention how they voted. There's no names that are associated with the ballots that are disputed based on the markings on the ballots. And finally, for the votes that have allegedly incorrect identifiers, please use the initials of those voters if it's necessary to refer to them. Looks like everyone's ready to go. Mr. Amodio, you may make your argument.
Thank you, Chief Justice and Justices. Good morning. My name is Tom Amodio, and I represent Appellant Kathryn Dodge, who is here with me today. Following the recount in this case, the division found that Ms. Dodge had lost the election to Bart LeBon by one vote. We submit that the division made 4 errors. It counted 2 ballots it should not have counted, and it rejected 2 that should have been counted. In the first instance, regarding a residency, under statute and constitution, a person must be a resident of Alaska and of their House district for at least 30 days before the election to be qualified to vote in that district. Here we have a written sworn statement from one voter who confirmed an affidavit that he is not a resident of House District 1, even though he cast a ballot in the race. In his affidavit, the voter states unequivocally, "My residence address in Fairbanks is in House District 4. Further states, "This was my only residence address in Fairbanks since at least February 2018 to the present," and further, he did not reside at his previous address in House District 1 at any time in 2018, and he does not intend to reside there in the future. The master, Judge Arseth, found that this affidavit was a clear statement of intent by the voter that he was not a resident of House District 1. Nevertheless, the master refused to consider the affidavit, even though there was no contrary or rebuttal evidence offered at the evidentiary hearing. Similarly, the division has chosen to rely on its records rather than on this current information. Thus, this presents the fundamental question of whether a person who does not reside in the district may nevertheless cast a ballot, and in this instance, possibly the deciding one, and have it counted because the division's records do not reflect his current Alaska address which is outside the district.
So, Mr. Amodio, I have a question about that. I apologize for interrupting your stream of thought. I think that our case law has recognized, and as a practical matter, I think that most of us recognize that there's going to be times when residents of a district have moved outside and notwithstanding have not changed their residency with the Division of Elections. And they're going to vote, and that vote is going to create that very problem that you identify. But it seems to me the real fundamental question here is the scope of review that this court is going to exercise in deciding whether or not we're even going to entertain that. You know, in this case, that affidavit was not before the director at the time that the recount was done and certified. And it's my understanding generally that when an appellate court looks at decisions of either trial courts or agencies, that we look at the decisions that the trial court or the agency director or commissioner made based on the record before them at the time. So how is it that this is substantially different such that we would actually consider so-called evidence that was not before the director and not presented until after the recount was completed?
First of all, the court has in the past considered this type of evidence in System v. Stout. and other cases.
In those cases, was this issue squarely brought forward, or is this the first case that someone has actually challenged that issue?
I don't know the answer to that, but they did, if you look at the Cisna case, there was an affidavit, and in fact, the court says that although counsel raised arguments contradicting the content of an affidavit that was presented at the evidentiary hearing in that case, that there was no contrary evidence offered, that it was just the affidavit and therefore the court. But it's not, the issue was not squarely before the court and it was not discussed at length. But it had been introduced and it had been considered, at least the footnote in the language of the court suggests that they had considered the information in that affidavit.
So there's some suggestion there, but if the issue was not squarely raised, it may have been that the court made a decision where the parties weren't challenging that, and therefore it wasn't before us. In the Fisher case and the Finkelstein case, there is some suggestion, at least, that the court is concerned about considering only things that were properly before the director up to the conclusion of the recount.
Right, and what we presented to the director during the recount was information and photographs and affidavits of our own people, including Ms. Dodge, showing that the claimed residence for this voter was apparently not abandoned, but an empty commercial building, and that no one resided there at the moment. And the director refused to entertain that or change her mind, pardon me. And subsequently, we had contact with the voter and we were able to get the affidavit, but we did not have it in time for the recount. That is correct. So I think if you look at your case law, a recount appeal, it is an unusual beast, a little different from the other, certainly not the same as election misconduct, but nevertheless the court, where there are factual issues that need to be resolved, the court, like it did here, will appoint a special master often, and then it will rely on a special master to take evidence or whatever. In our view, this is specific. We identified this one, and we believe it was appropriate for the court to take the evidence it did, and then to actually, this court, to rely on that to determine if that vote should be counted or not.
So the affiant was not present, though, to testify.
They were not.
The other parties didn't have a chance to cross-examine the affiant.
That is correct.
And obviously, they can't cross-examine the affidavit.
That is correct.
So under strict rules of evidence, isn't that evidence invalid anyway for purposes of consideration?
Well, it's under strict rules of evidence, but again, I think in this, obviously, if this is considered an administrative proceeding, the rules of evidence are relaxed. And on the other hand,
Are you saying that the hearing before the master was an administrative proceeding?
no, I don't believe it was.
proceeding?
I think the hearing before the master was a evidentiary hearing to take evidence and to fully explore the issues that would be before this court and resolve any factual issues. That's my understanding.
Well, wouldn't the same rules of evidence apply as in any court proceeding?
I guess they would apply to some extent. We did try to we asked the affiant to appear, and they would not respond, and they were living out of state, so we had no opportunity to bring them. And the master, Judge Arceth, declined to allow any of the exceptions to the hearsay rule to apply. It was a signed statement. The contrary evidence before this is his registration and his absentee ballot, which
Also
is
under oath.
I'm sorry.
Also made under oath.
Right. Yes, Your Honor. That's correct.
So we have a purported resident of a district making two contrary, in fact, diametrically opposed statements under oath. So why is this properly a recount appeal issue and not an election contest voter fraud issue?
I don't believe it rises to the level of voter fraud. I think it's more would be
A
voter
resident under oath claiming to be a resident in one submission and claiming not to be a resident in another submission and then voting. That's not a voter fraud issue?
in my experience, that kind of thing is more a voter mistake than a voter fraud. A voter fraud, I think, is more someone intentionally doing it. I don't think that was his intent. Obviously, his submission of an affidavit, a subsequent affidavit to his absentee ballot.
You don't think that when a voter signs under oath that I am a resident of House District 1 and then votes in House District 1, that that's not intentional?
It's intentional that they made the statement, yes, but I don't believe that they intended to defraud the election or the division.
Would have been handy for him to have showed up and testified at the hearing, wouldn't it?
Yes, Your Honor. We tried to do that, but there was not sufficient time, and he did not respond to our future communications, our later communications. Well, just to sum up on that point, we believe that the ballot should not have been counted. Then we have a more or less a flip side of that, and that is a resident of House District 1 whose vote the division refused to count in the recount. He provided an affidavit and testimony at the evidentiary hearing. He did confirm that he resides in House District 1 and has resided at the same address there for 10 years. Since he was a resident there and otherwise qualified, he had registered to vote in House District 1 at least 10 years ago and has maintained his residence and his registration on his own behalf there. However, when he tried to vote in this election at his usual precinct, he was told he's no longer on the rolls, and he cast a question ballot. The division rejected his vote in House District 1. The division's records had been changed as to this voter, unbeknownst to the voter, because he had filed for a permanent fund dividend. The division auto-updated his residence and without consulting him or seeking his approval, and registered him at his office address in a different district. The PFD application asked for his mailing address and a physical address, and he provided his office address in both cases, not where he lived, in part, as he testified, because he doesn't have mail service at his residence. He lives in an apartment. Apparently, there's no specific mail drop for his apartment. This results from the passage of the PFD initiative in 2016, which was designed to make it easier to register to vote, not harder. In fact, the policy behind the law was to eliminate, and I quote, needless bureaucratic requirements that made it more difficult for qualified citizens to exercise their right to vote, end quote. So, in this instance, the law is implemented to, in fact, impose bureaucratic requirements that make it more difficult, in this case impossible, for a properly registered voter to vote where he resides.
Well, it's not impossible, right? The statute also requires the division to send an opt-out notice, which they believe they sent him.
That is correct, Your Honor. There's no proof that it was actually sent in this instance. They did introduce evidence that they had asked a vendor to send it out. Mr. Bukanovich testified that he had never seen it and did not receive it to the best of his knowledge. But
and the special master never made a finding on that issue, whether he received it?
That the master did not, Your Honor.
What did the director do that was wrong here?
The director refused to count that voter's ballot.
Was it correct then for the director to change the voter's registration address based on the PFD application?
I believe that the PFD application is ambiguous enough and confusing enough. I certainly have signed that in the last couple of years without realizing what I was certifying. I knew I was certifying I'm a resident of Alaska, but I had no idea it affected my existing registration. And my understanding of the law was that it would register voters who were unregistered. And so therefore the PFD application, when you're putting it, says if I'm not a registered voter, I will agree to be registered at this address. I had no idea that it affected my current registration as a
Do you have
voter.
any response to the state's note that the intent language for that initiative included updating voter registration?
It said, I believe, that the division may or can update it. It didn't say it shall update it or had to update it. And I would suggest that if they were going to do it for at least a existing registration, it should be an opt-in situation rather than an opt-out. We will include it. If you check this and return it back, we'll update your information. Otherwise, we'll make no change. Because that way, at least, it gives the person who's properly registered the right to vote. So you have people who have never voted or never registered, so presumably haven't voted, who are now able to go down and vote, and you have this gentleman who has voted in the past, registered House as well. He could not have re-registered with the division at his other place because he doesn't reside there. He simply works there, and he still resides. So he would have committed fraud if he had tried to re-register as a division had registered him. And I'm about to run out of time, so if any further questions, I've saved some time for the end, so you can grill me some more afterwards.
Thank you, Mr. Ramon.
Thank you.
Ms. Stone?
Thank you. May it please the court, my name is Stacy Stone. I'm an attorney at Holmes, Whittle & Barcott, and we represent the intervenors Bart LeBon and the Alaska Republican Party. As an initial matter, I think it is of note that the special master in this instance, in his findings of facts and conclusions of law that he submitted to this court after reviewing in a lengthy evidentiary hearing all of the factual circumstances and the pertinent law in Alaska, that the director's decision with regard to the election recount should be upheld. It's important to consider why we're here today. The purpose of a recount appeal is to consider the decisions of the director at the recount and to review those. There's been discussion about, in this case, what extent do we go beyond the ballot? And that theme pervades all of the ballots that we talk about today. With regard to the cross appellees ballots, there were five that were specifically challenged. Two of those categories are marking categories. There was one that was an overvote. There was two that were considered not having touched the oval because the markings were actually to the opposite. They had created an oval and filled in their own oval rather than touching the oval. Then there were two absentee ballots that were referenced previously today with missed identifiers. So starting with the two absentee ballots, the question is, how far can this court go? And in our understanding, this is a matter of first impression for the court with regard to, can you look at one ballot in conjunction with another ballot and consider the information in those two ballots? Is that within the court's discretion to go beyond the facial validity of the ballot itself?
So let's go ahead, please.
Before we get to what we can do, isn't the preliminary question what the director can do?
Yes. And the director, when she looked at the ballot, she said it was facially invalid because it had a missed identifier. So therefore, the director said this ballot does not count. And as a preliminary matter, yes, that was a valid determination because there was not a proper identifier. However, if this court were to exercise its authority to go beyond the facial validity of the absentee envelope and look at all the evidence that was before the director on the date of the recall, then there is a question as to whether or not this court would consider looking at two ballots in conjunction with one another when two voters have the same residence address, they're witnessed by the same person, and the identifiers are clearly the identifiers for the other envelope.
So let me follow up on Justice Carney's question, getting back to the director's responsibility and duty. Really, before we get to the question of whether we can take a look at all of the ballots and then compare and see, could this have been a husband and wife who mistakenly, voted a ballot and put them in each other's envelope? Does the director have either the duty or even the authority to do that herself? Because she would have to do that same exercise. She would have to look at all of the other ballots in the district to see, is there another ballot that might match this one where they mistakenly put their ballots in the wrong envelope? Does the director have that ability, authority, or responsibility?
Under a strict interpretation of Alaska statute and law, no. She does not have the authority to go beyond the facial validity of the ballot. It says they have to have, with the absentee statutes, they have to have the identifier on the envelope that is there. So it's only in case precedent that when these recount appeals come to this court, that this court can consider beyond this. There's a suggestion that this court could consider beyond the absentee envelope the other information that was part of the recount.
When you say a suggestion, but in CISNA, and I think Mr. Amodio referred to this at 367, this court stated that it was not limited to the determining the facial validity, and went on to say the proper review includes the power to search underlying records and election materials to ensure that a vote was cast in compliance with Alaska's election laws, and the search includes inquiry into such issues as whether a voter was properly registered or was a resident of the district in which he or she voted. So haven't we decided that question, that we're not limited to the facial validity?
It has been decided. However, the cases specifically reference the word ballot, and even though this is a ballot, it's an absentee envelope, so there would have to be essentially a statement in a finding that we're allowed to also look at the envelopes. This ballot has never been opened. It's never been counted. It's never been reviewed by the division. So we don't actually even know what the ballot is in this instance.
Thank you.
With regard to the overvote, as I stated, there was a mismarking on 3 separate ballots, and that's what the special master found, was that with regard to the overvoted ballot, that pursuant to Edgman, that he believed that that was clear error because there was a mark. We maintain that because of the statute that says that a horizontal line is a valid mark, that it could be considered an overvote, and that this court needs to review and make a determination with regard to the same.
Isn't this the same issue that we had in Edgman?
It's very similar, and it's a determination of what classifies an errant mark. So it is a similar situation, and we concede that it's a similar situation. However, because it is a valid mark, we feel that it's necessary to bring it before this court.
If the situation is indeed ambiguous, aren't we bound to make a decision that tries to accord with the voter's intent?
Yes, I do believe so, and that leads me to the second part of those marking issues with regard to the right-sided ballot ovals. When someone's making a right-sided ballot oval, they're filling in an oval, and even though it's not touching the oval that was printed on the machine, when you look at the ballot, they clearly only selected one candidate in each of the races on the first page of the ballot.
How's this different than the issue we decided in Miller, where some voters had written in the word Murkowski but didn't fill in the oval?
In that case, there was no oval. It wasn't that they wrote Murkowski and oval. It was that they failed to circle the oval when they wrote in the name Murkowski, and that's my understanding from the case. And therefore, in this case, there is an oval, and they circled an oval, and in one case, they even filled in parentheses to circle an oval. And it was pointed out, too, that in page 2, they had marked yes or no. That came up during the evidentiary hearing. However, yes or no follows the question that's presented on page 2 of the ballot, similarly to where that voter voted on the front page where they voted underneath the name.
The statute doesn't say you have to fill in an oval. It says you have to fill in the oval provided. And it's also the statute that says we have to follow it very strictly. We can't vary from those requirements. How can we follow your argument and comply with the statute?
I think it's important because this court has said that those election laws are directory, not mandatory, following an election recount. And with regard to voter intent being paramount, it's necessary to consider those ballots and whether voter intent is discernible.
But we're always construing a ballot after the election. So how does that provision in the statute that says we have to construe these provisions for construing a ballot strictly apply if it's only directory?
Like I said, I think it's because the paramount in all of the cases before the court and many of the cases before the federal Supreme Court, the issue is, can we discern the voter intent?
Well, that can't be so, because that Murkowski case that you were just referring to is clear to everybody. But that's what the voter's intent was. But under the circumstances of that particular statutory requirement, it wasn't enough to write her name down. There had to be a filling in of the oval, right?
In that case, like I said, there was no oval filled in, so I believe this is distinguishable and that the court could consider it, that there was an oval that was filled in. So was the voter trying to comply with election law by filling in an oval, even though it wasn't the oval?
What if one of them looks more like a square?
If one of them looks more like a square, then I would say that it may be a further question, but where it looks clearly like they're trying to make an oval mark, I think that there's a question to be had to this court.
Do you dispute the state's characterization of the rule that we construe the statutory provisions as directory to uphold the division's decision?
Yes.
Do you have any cases that go the other way?
And I apologize. I don't right now. But I believe that what the case law says is that when this court is charged with the appeal of a recount, that they are to look at those statutory provisions that bind an election as directory rather than mandatory, especially when it comes to voters and disenfranchising voters to where their ballot will not be cast.
Doesn't that directory mandatory language that originally came from Carr, I think, have included in it a provision that says unless, there's 3 unlesses, and the third unless is unless the legislature essentially is directed otherwise?
Yes, and like I said, it is the law is clear that that the person is to fill in the oval.
And in this legislation it says, B, the rules set out in this section are mandatory and there are no exceptions to them. A ballot may not be counted unless marked in compliance with these rules. Doesn't that suggest that activates that third unless?
That is in the case. Like I said, it is mandatory. It is a mandatory provision. It says that in the law. I think this court has more discretion. And as I stated, because the voter created an oval and filled in
the legislature's directive that this is mandatory and there are no exceptions?
I believe filling in the oval is mandatory, and even though it says the oval, when it comes to voter and where voters make a mistake, I believe that it's for the court's consideration as to whether their intent can be determined and whether their vote should be cast, and they should not be disenfranchised. Moving on to briefly address those points brought up by Mr. Amodio. With regard to the PFD issue, in our briefing we set forth a situation that was somewhat similar in the Willis case, wherein there's a purging statute that says that the Division of Elections after a certain number of years can purge voters from the voter rolls. This requires no action of the voter except that they did not vote. So it's not the voter coming in and saying, I don't want to be registered in this district anymore, I don't have this residence anymore, I moved to California, whatever the case may be. And in that case, the special master found that because this was consistent with statutory norms and the practice of the Division of Elections, that was proper and that those ballots should be rejected. We liken that to the PFD situation here with regard to a statute that provides for this process wherein people's addresses will be updated or people will be registered to vote unless they fill out this opt-out notice. So therefore, we feel that the director properly rejected that ballot and that the special master made the proper decision with regard to the facts in the law.
What about the situation in Fisher versus Stout, where the voter received a voter registration card that had an incorrect address, sent the card back to the division with the address crossed out and apparently a mark that would otherwise cancel the registration, but under the circumstances, apparently the court felt that it was clear that the voter intended just to change the address on the registration. Isn't that the same situation as we have here?
I don't think it is the same, because that is where a person was improperly registered to vote at an address. They felt they crossed out that address, they returned it to the division, and therefore, in that instance, they would be complying with AS 1505-0208, because that statutory provision provides that the presumption with regard to residency is only negated by a written notification to the director. So therefore, because this person is giving written notification to the director that their voter residency should change, then I believe that would be valid. And that's the case here, wherein when we get to the next ballots with regard to the voters whose residency was questioned, at the time of the recount, AS 15050208 would provide that notification had to be in writing to the director, not to the court, but to the director. And I think that language is important when we're looking at legislative intent. And this court, while not squarely before it, in Cissna v. Stout, reiterates that it's written notice to the election officials that rebuts the presumption of residency. And here we don't have written notice to the Division of Elections from...
Didn't candidate Dodge actually file the affidavit with the division, although it was after the recount?
I don't believe it was timely. I think that this court has to decide where the line is with regard to timeliness. The court has looked at this in the Finkelstein case. In Finkelstein, there was post-election affidavits that were raised demonstrating non-residency, and they were not considered because the objection was untimely. And while this case is a little bit distinguishable because there was a challenge made with regard to these voters, we maintain that that challenge was not the objection that's set forth before the court today with regard to questioning whether this affidavit comes into the court or not. There's a question before the court of when does it end? Can you bring up additional evidence through the recount, which is our position that once it goes through the recount is certified. Unless there's an election contest, that record is what the record is. The other opportunity essentially would be, can someone bring an affidavit today and say, hey, I have an affidavit of so-and-so, they aren't a resident of House District 1, but they voted in this election. Or is it swearing in of the candidate to say, hey, there was a problem with the election? Now, there would be an issue with regard to the filing of the timing of the recount appeal in any election contest, but essentially, based on the precedent that's before us today, it's our belief that that affidavit is untimely and should not be considered because it was not before the director at the time of the recount. That information was not available to her, nor is it part of the record.
I have a slightly different question, and you may have touched on this previously, but in your description of the record, does it include all of the records of the Division of Elections and associated records of the state up to the time of the recount, or is it limited to the records that the director actually reviewed?
I believe that based on the statute that provides for a recount, that the record is the election materials that were available at the time of the recount. I think that Willis v. Thomas underscores this point with regard to what is the record in a recount appeal. And with regard to a recount appeal, as I stated, the director did not have it for her at the time. She could not consider it, and therefore it would not be part of the purview of whether this vote should be counted or not. And with regard to what is a recount appeal, what you will find in the court record essentially is every document that the division had that they represented pertained to the challenged ballots. In closing, it's our position that in this case, this court should likely defer to the director and affirm the special master's determinations that with regard to the director's determination at the recount that those decisions made by her were proper, and therefore the certification should be upheld. In the event that it's not upheld, interveners wish that this court consider the 5 ballots that it presented.
So I've got a question
Yes.
for you about that. For the first time now you're arguing, at least before us, that we should defer to the director. Why would we defer to the director?
I apologize. I meant to defer to the special master.
Why would we defer to the special master?
I think that there's...
We hear these recount appeals de novo.
Yes, you do hear these recount appeals de novo, but this court has charged the special master to look at the facts and the case law presented with regard to what occurred in this case. I believe in, and I apologize using the word defer, I meant affirm the determinations that were made by the special master, and that is the language used in other Supreme Court cases where there has been a special master appointed. They affirm the determinations that were set forth to them by the special master. Thank you.
Thank you, Ms. Stone. Ms. Demarest.
May it please the Court, good morning. My name is Kate Demarest, and I'm here representing the appellees from the Division of Elections. This is a recount appeal. It's not an election contest. The scope of the inquiry and this court's task is set forth very clearly in Alaska Statute 15-20-510. And the sentence I'd like to highlight from there reads, "The inquiry in the appeal shall extend to the questions whether or not the director has properly determined what ballots, parts of ballots, or marks for candidates on ballots are valid." We have 9 ballots at issue. I think we've touched 8 of them so far this morning. Excuse me, and I'm going to try to touch on all 9 in my time here. For each one of these ballots, all 9 of them, there is a statute or a combination of statutes in Title 15 that clearly answers the question before this court on validity. For most of them, this court has also previously decided either an identical or a very similar question. And in every case, this court's precedents reinforce the results compelled by the election statutes. I'm going to go through them in categories sort of as they were addressed by the special master, beginning with what the division views as sort of the simplest questions, and I'll try to end where Mr. Amodio began on what I think is the trickiest one of the 9. First, we have the ballot marking issues. There's the overvote ballot, which is the one I haven't heard anybody discuss so far this morning. That's the one where both ovals were filled in, and then there's an X over the oval for Mr. LeBon. This one is controlled by Alaska's very, very detailed ballot marking statute. We have a strict and detailed statute that covers this subject. Alaska Statute 15-15-360A1 lists the types of acceptable ballot markings. It's an exclusive list. It says only, and it includes both filling in the oval as an acceptable way to vote and also making an X mark. Then we have the overvote provision of that statute, A4.
Let me ask you a question about that one initially.
Yes, sir.
I recognize that the statute recognizes both an X and filling in the oval as a valid mark, but doesn't an X mean different things to most people if it's over an empty oval as opposed to over an oval that's already been filled in? I mean, if I write my name on a blank and then I X it out, that doesn't mean that I've signed it twice. It means that I don't want my name to appear there.
Certainly, and you know, Ms. Dodge looks at that ballot, and that's what she sees is an intent to cancel that vote. The LeBon side looks at that exact same ballot and sees an intent to double mark the vote for him, which is why the statute helps us in light of ambiguous voter intent here. And in Section A4, the overvote provision, it says that if the voter marks more names than there are persons to be elected, the vote may not be counted. And you know, many people might look at that ballot and share your view that that X is intended to cancel the vote. Others, Judge Arseth, saw two valid marks is more than one valid mark and said in the alternative that maybe that means it's a vote for Mr. LeBon. The division sees both sides, which is why this ballot cannot be counted. It's an overvote.
Is it our job to determine which result is more likely, or are we bound by the statute?
You're bound by the statute in this particular situation. The second one, the alleged overvote, the one that Ms. Stone referred to, and we just had the discussion about the Edgemont decision. In that case, what we have on the second marking, what we'll call the second marking, is a trace on the edge of the LeBon oval. And this court has already decided in the Edgemont case that a trace on the edge of the oval is the issue as the court articulated it in Edgemont was whether the marking next to the second name constitutes a mark sufficient to designate a vote. And this court held there that the trace on the edge of the oval was not a valid mark and therefore counted the one that was a valid mark, which was the filled-in oval, which is what the director did here.
Section 360 does recognize a horizontal mark as a mark. Doesn't this cut against the argument you just made with respect to the first ballot?
I mean, I do think a horizontal mark that somebody's using in their A5 does include voter intent as part of the analysis under 360. And if somebody makes a straight line right through the middle and marks every oval that way, that's a horizontal mark that's a compliant vote. I think this might have been it's very helpful that Edgemont has already decided this case. If you look at that ballot, it clearly looks like a person starting to make, it's not a horizontal mark that's selecting that oval. It's a person starting to do exactly what they've done on every other oval. They've made one little mark and said, oh, nope, that's not it, and then they make a complete mark. So I don't think that little trace on the edge is the same as a horizontal mark under the statute. At least that's what this court determined in Edgemont as I read that case. Next we have the undervoted ballots, the ones that Ms. Stone was just discussing with you, which are the ballots where voters made marks to the right of the candidates' names and did not mark anywhere near the oval provided. And as the court has already acknowledged and discussed with Ms. Stone, Section A5 says a mark shall be counted, quote, only if it is substantially inside the oval provided, not a different oval, but the oval provided, or touching the oval so as to indicate clearly that the voter intended the particular oval to be designated. And again, subsection B says that these ballot marking provisions are mandatory and there are no exceptions. In Miller versus Treadwell, this court confirmed that it will apply that statute and not elevate voter intent over compliance with the ballot marking statute because it's mandatory. And here, you cannot reach a different conclusion as to these two ballots. Ms. Stone says they're distinguishable, but the fact is, in order to reach a different conclusion as to these ovals that arguably the voters created, you have to both rewrite the statute and also overturn that portion of Miller. And so we contend that their director correctly applied the statute, and that both the statute and Miller together compel the result that these ballots were not compliant.
So I want to play devil's advocate here for just a second with you. If you take a look at this ballot that we're talking about, the instructions say to vote completely, fill in the oval next to your choice like this. And then there's an oval immediately to the right of that sentence. And the form indicates that they're filling in the oval to the right of the sentence. So a voter might be able to read that and say, okay, they're telling me to fill in. And of course, once it's all filled in, you don't know if that's an oval necessarily, or parentheses. Now you've got them filling in, the voters filling in, the parentheses that contains the party affiliation to the right. Isn't that a reasonable construction here of a voter attempting to follow the example?
It is certainly a reasonable construction of the voter's intent, just as it's reasonable to look at the ballots in Miller versus Treadwell and see we can all tell these voters meant to vote for Lisa Murkowski. It is not a reasonable interpretation of the statute, unfortunately, which is mandatory and says the oval provided, not the one that the voter draws. So I would return to what I just said, which is that we have to follow the language of the statute, even in some cases like this one, in the case where voter intent can be discerned. We only use voter intent to make a determination between sort of ambiguous marks, which is the one that shows intent. Here, but you have to first comply with the ballot marking statute before you do that. The next two ballots we have are the incorrect identifier pair, which are in the record at State 123 and 126, and you can see them with the confidential identifying information not redacted in the confidential envelope that we filed. Here again, just as every one of these ballots, as I've said, there is statutory and in this case a regulation on point that control the result. Here, first we have Alaska Statute 1520-081F, which says the director shall require a voter casting an absentee ballot by mail to provide proof of identification or other information to aid in the establishment of the voter's identity as prescribed by regulations. Then we have the regulation on point, which says the voter shall provide at least one form of identification specified in B, and the forms of identification specified in B include different things like a voter ID number, driver's license number, some others. And it says the voter must do that at the time the voter executes the voter's certificate, which is the key language here, not somebody else's certificate, but their own certificate in voting an absentee ballot by mail. And finally, Alaska Statute 1520-203B1 says an absentee ballot may not be counted if the voter has failed to properly execute the certificate. And Ms. Stone concedes that the voters did not comply with the plain language of these statutes. The voters put their ID numbers on somebody else's envelope. And she also concedes that there's no precedent to look at the two ballots together and find substantial compliance and excuse the voter from these mandatory requirements, these identification requirements. And she's right, technically, that this is maybe to some extent a new situation, but we have the Finkelstein case, which addresses a very, very similar requirement that serves a very similar purpose, which is the witnessing requirement. And Finkelstein says that that is a mandatory requirement, not a directory one, because it serves a function that is critical to the operation of the absentee ballot system and the operation of the integrity of the election.
But this looks like it's probably an innocent mix-up, right? Everybody has assumed that this is a husband and wife that just mixed up
Perhaps.
envelope.
Probably, but it is, I think, an accident that we're able to see that at all. And as I think it was Justice Stowers was pointing out, you know, if two voters made this same error who did not live in the same household, did not have the same last name, it would be much more unlikely for the director to notice it. And so, and the statutory language is really clear. This mandatory versus directory case law doesn't say ignore clear statutes in favor of counting votes, no matter what.
Or common sense.
Well, sure. I mean, and there are times where you just have to draw bright lines, and there will be situations that fall, because without bright lines, you can't have the very important principles of having administrability and conduct of the election. That mandatory versus directory language, it's a statutory interpretation principle where you have two potential constructions that are both reasonable, and one favors enfranchising voters, the court should choose that one, of course. But where there's only one reasonable interpretation of the statute, which is provide your identifier on your own ballot envelope, that principle does not apply. So unless there are any questions on those, I will move to the last three, which are the residency challenges, which I think are the most interesting ones. First, we have the PFD registration voter. This voter provided his question ballot envelope. It's at State 7. He was not registered in House District 1, so his ballot was a partial count, meaning all his votes were counted except the one for House District 1. The residency presumption statute controls here. That's Alaska Statute 15050208. The address of the voter as it appears on the official voter registration record is presumptive evidence of the person's voting residence. This presumption is negated only if the voter notifies the director in writing of a change in voting residence. And the Finkelstein case really reinforces that this statute means what it says, which is that you have to have a clear expression of intent from the voter in order to change the legal residence. And
is that different from the standard we applied in the Fisher case? Because in Fisher, going back to the illustration that Justice Bolger referred to a moment ago, where the voter checked the box that mistakenly canceled his registration. He didn't mean to do that. He just meant to send in this card that changed his address or to inform the division of his correct address. And mistakenly, he canceled his registration. And what we said in that case was, and I quote, "The voter's franchise will not be withdrawn unless the voter's intent to have it withdrawn is clearly and unambiguously expressed."
That voter in that case, I think, clearly and unambiguously expressed his intent to change his address, as did this voter, whether he meant to or not.
So it's the division's position that his signing the PFD form was a clear and unambiguous expression of intent to be disenfranchised?
Yes, whether it was intentional or not. That's exactly what it said. He had notice of it
How
when
can
he
you intentionally change your address?
Well, what he did was intentionally completed a application for a PFD. And what Dodge is challenging here really is the fact that the division changed his registered address back in 2017, not so much the fact that they didn't count his vote in 2018. But he went online, as we all do every year. He filled out that form intentionally. That form, the PFD form, gives clear notice that a voter will be registered, quote, at the address provided on this application. And the division followed the PFD voter registration law as it was absolutely required to do. The division had no choice but to change this voter's registration.
Excuse me, but aren't we worried? I mean, isn't the concern, I'll tell you, my concern is that the form says, I understand I'll be automatically registered to vote, but doesn't talk about update or change of previous registration. Isn't that the concern?
Mr. Amodio said that it is his understanding that the PFD law was only going to register new voters. And, you know, maybe that's an issue of how the law was publicized. I'm not sure. But the language of the statute itself.
The form that Mr. Bekanovich
The form, well, first of all, the division didn't make that form. The Department of Revenue made that form. The division's job is to follow the PFD statute and do what it says. So the form says...
required to warn a PFD applicant that their voter's registration will be changed?
Yes, and that is what the division did. The division, so the PFD voter registration law itself says, so we'll walk through the relevant provisions of that statute, which also control this ballot. 1507070I says the division shall register voters in accordance with J through M of the section. Then in subsection K, this is where the duty to warn is that Justice Bolger just mentioned. The division must send a notice to, quote, each applicant not already registered to vote at the address provided in the PFD application, and it has to give the voter notification of what to do if they want to, quote, maintain an existing voter registration at a different address other than the one that they provided on their PFD application. And if the voter does not provide that opt-out notice back to the division, Mr. Amodio suggested that in his view it would be better to have an opt-in than an opt-out. Well, that's not the law that the initiative passed. We have an opt-out law, not an opt-in. And the division can't rewrite that law and decide, oh, we're only going to do new voter registrants. They must follow this statute, which says, give people notice that we're going to re-register you at the address you provided. If you don't want us to do that, then let us know, and we'll keep you at whatever address you had before. That's what the PFD law that the voters passed in the 2016 initiative says. And the division cannot excuse people from that because they didn't understand that that's what they were doing. They didn't read the form. They didn't open their mail. And so...
Well, Mr. Bukanovich testified about his office practices and about the way in which he received mail at his office, and the receptionist went through it, and he testified that he didn't think that she would throw away something official from the government. So we've got testimony from him about what his usual practice was. We have testimony from the director about what she assumed that their vendor did, and there's no finding from the court, from the special master, as to what actually happened. And in these circumstances, I don't know that we can divine what can actually happen. Why should we elevate the divisions, what they assume to be their standard practice, having followed their standard practice, over Mr. Bukanovich's explanation of what his standard practice was?
Mr. Bukanovich's testimony about his intent or about his mail or his receptionist, which incidentally he also testified consistently that he probably didn't have that receptionist at the time when this would have come in the mail. But in any event, none of that evidence was available to the director. It's all outside the scope of a recount appeal. What we have to look at is what the director did and what information was available to the director at the time of the recount. And that information was, number one, Mr. Bukanovich applied for a PFD in House District 2, putting a House District 2 address in 2017. His name was on the list with everybody else whose address on their PFD application was different than the one that where they were previously registered. Therefore, his name went to the vendor, and there's no reason therefore the division can only conclude that they have followed the PFD law as it is written, and that Mr. Bukanovich never opted out. The operation, as it's an opt-out system, and it doesn't depend on whether or not the Postal Service lost the mail, doesn't change the effect of the voter registration. The PFD law.
It doesn't matter whether the opt-out notice was even sent?
Well, it matters that the division did what the division was required to do under the statute, and there's no evidence that the division did not do that. The only evidence we have is the division's records, which says, yes, we included Mr. Bukanovich on the list.
But if the third-party vendor, for some reason, let it slip through, that doesn't matter from your perspective?
No, that doesn't change. That doesn't mean that the division made an error in changing his registration, because the division was required to do so under the PFD law.
Can I ask you one more question about this, which is, I think, to me, the most troubling question in the case? Was Mr. Bukanovich essentially disenfranchised? In other words, as to voting for a state representative, in that it would have been improper for him to vote in House District 2, where his law office or where his office address was, because that wasn't his residence, right?
Right.
So he couldn't. So it's your view that he simply wasn't registered to vote for a state representative? If
he had gone to House District 2 and voted, he wasn't a resident there, but the residency presumption would have said that he was. And he could have voted in House District 2.
And should that vote have been counted if it were determined that that was not his residence?
It depends on the timing when he informed the director in writing that was not his residence.
So really, how does that comply then with the language that I read earlier from CISNA, indicating that our proper review includes the power to search all of the underlying records and election materials to ensure that the vote was cast in compliance with the law? And if, in fact, House District 2 was not his residence and House District 1 was, and we know that as a fact, you're saying it would be better to allow him to cast a vote where he didn't live and count that vote than to count the vote where he did live?
The records that the division can search under CISNA would not have included any evidence that Mr. Bakanovich lived anywhere other than House District 2. Therefore, he would have been.
Talks about this court's review, though, not what the director has available, correct? The proper review of this court includes the power to search underlying records.
The underlying records, but that doesn't mean any post-recount evidence. CISNA does not allow the search of any post-recount evidence. It allows search of things beyond the face of the ballots themselves. In other words, the registration records and the data that the division, the court and the division can certainly look at things like, did we send the opt-out notice as required by the statute? There's nothing in CISNA that suggests that either the director, of course the director can't possibly look beyond the date of the recount, but there's nothing in CISNA to suggest that this court can do that either.
Haven't our referrals to a special master in similar cases specified that the special master can consider both, can consider extrinsic evidence?
Never in a peer recount appeal has post-recount evidence been considered. Mr. Amodio argued, I think, that there's an affidavit that he thought was post-recount affidavit in CISNA that was considered. That was an affidavit of the director, which is about the division's own records. There has never been a peer recount appeal that was not also an election contest where post-recount evidence was considered.
Counsel, I think you're out of time.
I am, and I haven't spoken about Mr. Odom's ballot, but in any event, we're out of time, so we just ask the court to uphold the director's decisions on all 9 challenge ballots and the certification of the election.
Thank you. Mr. Clerk, would you please add 2 minutes to Mr. Amodio's rebuttal? Sir?
Thank you. I'll be brief. Ms. Demarest points the court to statutes, and I would say as to Mr. Bakanovich, one statute to look at is 1507090, which talks about the transfer of registration from of a voter from one House district to another, and I believe that this statute, which is still there, and the other is controlling here, and also that the division did not send, regardless of the opt-out notice, Mr. Bakanovich did not receive a new voter registration card, updating his information. If that had come in the mail, presumably he would have said, wait a minute, I don't live here, and he could have taken steps to address that. Back in 2017, no such card. He testified that there was no such card issued to him, so he still had his old registration card. Briefly, as to the so-called overvoted ballot, I think if you look at that ballot, as we all have, the voter voted by filling in the ovals for every single one. There was no X's except in one place, and that was to X out the apparent vote for Mr. LeBon. I know in my own experience that it was never a good sign to see an X overthrew one of my answers on a test or on a homework assignment. It always meant wrong. You don't get points for this. And in the same way, I think that when you look at that ballot as a whole, you can only reach one reasonable conclusion, that is the voter intended to cancel out that particular vote. And then I know the court has already said some of these things, but as the court has, I'll quote from this court in some of the other cases, that a voter's franchise will not be withdrawn unless the voter's intent to have it withdrawn is clearly and unambiguously expressed this, I believe, applies quite strongly to Mr. Pekanovich. That's in the Finkelstein and also in the Fisher cases. And then
does that idea apply even if the vote doesn't comply with statutes? Is the voter's intent paramount even if the vote does not comply with state statutes?
I'm sorry, in which vote are we talking about?
Well, I mean, I just in general. I mean, is that a paramount consideration that applies over the various different statutes we've been talking about here today?
Yes, I mean, the statutes do govern the election, but also that the voter's franchise is not withdrawn. So basically, as I pointed out, too, that the whole point of the PFD initiative was to expand the franchise, not to withdraw or to somehow narrow it and restrict it to already registered voters.
Your challenge with respect to this voter, wouldn't that apply to everyone that is on the list of PFD applicants that the director testified about? The list of those whose PFD applications were different than their voters' registrations, the list to which she sent the opt-out notice. It applies across the board.
It would apply if there was any. I mean, it could apply. It's just that this is the only one we're aware of in this that has any impact in a case, an existing case.
Isn't that kind of a broad challenge, the type of a challenge that should be brought in an election contest?
I don't believe so. I think that's proper for an election recount, and maybe if it was a broader situation, but we just have the one voter here who voted a question ballot, and the question is, should that question ballot be counted or not? And the division says, we changed his address for him, we changed his house district, and therefore he can't vote in this house district, the only one that where it really counts, because none of the other races, one vote would make any difference. So the one race where it makes a difference, and he's been there for 10 years and resided and registered there properly and had voted in past years, he finds out now he can't vote, that he's been disenfranchised. So, and then the other one, which I call the court's attention to, comes from Carr, that courts are reluctant to permit a wholesale disenfranchisement of qualified electors through no fault of their own, and where any reasonable construction of a statute can be found which will avoid such a result.
See, here's my question to you, though, my trouble with your argument, and it's that phrase, through no fault of their own. This individual actually filled out that PFD application and made certain choices in that application. Now, he may have understood or he may not have understood the consequence of those choices, but this was his act and not the division's act that caused his registration to change. Isn't that right?
His filling out of the PFD application, yes.
So if he was disenfranchised, and I'm not sure that's the right word, but he disenfranchised himself. It wasn't the division that did that.
Well, I guess that's one way of looking at it. I think it's the division's automatically taking that and...
According to law.
Well,
it wasn't an exercise of discretion that the division was working with. They're trying to follow the law, right?
Yes, but I believe that the statute can be interpreted to allow for someone who's already registered, like I say.
And does the director of division have the authority or the ability even to make those kinds of determinations that the statute or the initiative itself was unclear?
Well, the division certainly has the ability to send out a new registration card with the updated that would then show clearly. And Mr. Pekanovich testified he did not receive any notice to his knowledge of any change. So he had no idea until he went there to vote that this change had been made. So, and that's, I guess, what this court has to decide.
Thank you, sir.
Anyway, that is all I have to say, unless the court has some additional questions. But thank you very much for your time.
Thank you, counsel. And thank you, to all counsel for your really outstanding briefing and argument on these difficult questions. I know that all parties are very interested in the answer to these questions. We'll take the matter under advisement, and we will make a decision as soon as reasonably possible. We'll be in recess.